Okay, we're going to walk through this. Can a school conduct a placement trial without giving prior written notice to the parents? No. No, not if there's an IEP in place, and if that IEP is written to be done in a certain way, in a certain classroom, in a certain location, and on a certain schedule, then absolutely not. The parent needs to be a equal and valuable and participatory member on the IEP team, and that includes making these kind of determinations. They cannot be determined without the parent's consent, without their participation, and without their, well, I was going to say without their consensus, but that isn't the case. I mean, if the IEP team and if there's a disagreement on the IEP team between, let's say, the parent and other members of the IEP team, and consensus isn't reached, it doesn't mean that it stops that from continuing. It just means that it now sets into motion the mechanisms for the parent to challenge the determination, either through a facilitated IEP meeting, a state complaint, mediation, or due process complaint. That's how you handle, when consensus isn't reached. And then that's where prior written notice would come in. But, consent, an understanding when and where this determination happened. So let's say, for example, that you had your IEP meeting, and in that IEP meeting they floated the idea of altering the schedule. Then yes, then they did, at that point you did have notice that they were thinking about doing it, and at that point, you should have had it. There should be some kind of written documentation as to that the determination was that this was going to occur and data was going to be taken. I have seen that before, but at the same time, the parent needs to have notice that it's occurring. It must have been discussed and determined in a meeting. And if there was a disagreement, then at that point, prior written notice should be provided. At that point, then would trigger the options for the parents on how to deal with it, okay? I know they can't change the placement without an IEP meeting and sign consent, but can they do a trial placement without notifying? No. And you're in North California. Should I have said that? Because I usually, there's no other identifying information. So, okay, your daughter told you that she's taken out of her special day class to mainstream classroom. They told her it was a trial, but also changed her schedule. Now, let me also say this. If you agreed to any kind of an assessment, let's say a functional behavior assessment, and the IEP team is trying to determine whether or not your child needs to be integrated, and there needs to be a future discussion on a move along the least restrictive environment continuum to where the goal is always inclusion, more inclusion, general education exposure, general education involvement. That's always the goal. So if the determination was, well, let's take some data, functional behavior assessment. Well, what's the best way to get a functional behavior assessment done? Well, in the environment where the behavior is occurring or where the consideration for placement is going to take place. You don't want to do an FBA in, let's say, a self-contained environment when the dispute's over here on how your child's going to act in a general education environment. That's not going to show you anything, taking data here. Because a child's behavior isn't necessarily, the antecedent may not be here. The antecedent may be over here. So that's why you need to do a functional behavior assessment in the environments. And that's why, every year when I see these cases come before me and it's just such a mess, I'm sitting there going, where's the new behavior plan? Well, we're using the behavior plan from last year. But you were in a whole different school. The child moved up to a completely different environment. So who in their genius thought that this behavior plan would be applicable in this new environment? You need to do another FBA if you start seeing behaviors. You don't sit there and wait for 9 weeks or wait for a semester and everybody start waving the white flag going, I just don't understand what's going on. Yes, you do. You didn't do it. So in this particular situation, I mean, I wasn't at your IEP meeting, but I'm sort of trying to cover all bases, because you may have consented I'm not necessarily talking about written consent. I'm talking about just being a member of an IEP team when discussion is going on about considerations of future determinations. And in that situation, then it wouldn't be inappropriate, because you were a participant in those discussions. And unless you absolutely disagreed in the meeting and it needed to be notated somewhere, then there's nothing wrong with them taking data. I mean, hell, I have that happen all the time in my cases. We want to know. It's a smart thing to do. We want to take the data. Everything that we do in special education should be data driven. Not hairs on the neck, back of your neck and ookly feelings and thought and theory. I mean, it's not how you do it. It's not the best practice. Best practice is data driven decisions. That's what keeps everybody out of trouble. And it's a simple way to do it. And even if it consumes a little bit more time and some additional resources, guys, you know how much due process cases cost? The schools, just they are not prioritizing their resources, and it's insane what an ounce of prevention ends up saving long term. But I've been shouting that message for a while now. Since the beginning of school, they expressed their intent to move my daughter, but I told them that before making any changes, they needed to comply with the settlement agreement resolutions we went to due process a few months ago, and then wait for the IE. Oh, see, maybe I should start reading a lot of these questions before I answer them. Yes, they need to make sure that they comply with the terms of the settlement agreement, but at the same time, here you go. Prior written notice, change of placement. I wouldn't consider that a change in placement. I would consider that if they express their intent and their desire to move your daughter and they're taking data collection, you're traipsing into some gray areas as to whether that's a true change in placement. I mean, you got to look at it this way. Let's say your child has a bunch of discipline problems. The school system has the ability to suspend your child for 10 days without letting you know, not giving you a reason. Who cares? That's even if your child has a behavior plan. Every school, if your child has a 504 or an IEP, they can suspend you for up to 10 days, and you just, for any reason. It's after that 10 days, and that's 10 total days throughout the school years. It's only after that 10 days that it tips into a potential change in placement and a violation of the IEP. After 10 days. All right? So if they're sitting there and you did have notice and they're taking data and they're being a little flexible, there's some arguments to be made on both sides as to whether that's a violation, whether it's not a violation. Is it written anywhere definitive that, like I said, there's a lot of things going on here. Now, I am not saying that it's not a violation of your agreement, because you have the four corners of the document, and whatever's specified in the four corners of that document, that should take priority and that should take primacy. And at that point, they may be in violation of your contract, not necessarily in violation of the IEP. They are not the same thing. For the reasons that I've stated. I mean, easy solution. I mean, you just go back to your IEP team and you just sort of get it definitive and to sort of put the stopper on it and say, whatever consent you assumed I gave, or whatever discussion was had in an IEP meeting, I no longer, I understand what you guys are trying to do, but that's where you would have to stop it. Because having a general discussion in an IEP meeting and then having the implementation of it like I said, isn't necessarily something that requires your consent. If the data collection, if there's a reasonable justification for why they're taking the data collection, so you'd need to back that up, and it would need to be in a formal meeting and not something that you do outside of that. Okay, a lot of steps, I know, and this is an interesting question. I appreciate you answering it.